Hello, I'm Linda McCauley and welcome to this podcast of On Your Behalf. And this morning, the train journey that left one listener swaying in the aisle. The cost of childcare. Are some parents having to turn to payday loans? And enduring powers of attorney. Do you have one? Will it work? A very important discussion on today's programme. I have a spokesman from the Law Society in the studio with me. So if you've got a question, pick up the phone 030 30 80 55 55, text 81771 or email oyb@bbc.co.uk. Now, we often talk about enduring powers of attorney on your behalf, and we all assume we'll be able to manage our financial affairs throughout our lives, that we'll always be able to get to the bank and understand our financial transactions and the implications. But an accident, an injury or an illness could suddenly make a big change to our lives. Now, Anne, and that's not her real name, emailed oyb@bbc.co.uk to share her story, and she began by telling me why, 16 years ago, she and her husband decided to sort out their wills and draw up an enduring power of attorney.
We lived in Bristol for 32 years, and during that time he needed a triple bypass, which he had done in Bristol, but beforehand he wanted to make his will, and we made joint wills and at the same time drew up joint powers of attorney.
That was a very sensible thing to do.
Yes. Well, we had known somebody who had problems because they didn't have it. We lived in England until my husband retired, then came back here in 2003. I informed my solicitor in Bristol that we were moving back and asked him to hold our documents if that was okay with him, and he agreed to that.
So at this point you thought you'd done the right thing and everything was pretty much legally watertight?
We felt that we had made everything as watertight as we could make it.
Well, that's Anne, and she and her husband were doing what they thought was the right thing to do at the right time, what they thought would be in their best interest. Brian Spears, spokesman for the Law Society in Northern Ireland, is with me, and the phone lines are open if you have a question, 030 30 80 55 55, or text on 81771. Brian, you and the members of your Law Society have often said in this programme an enduring power of attorney is a very important document. Just what is it and what does it provide for?
Well, good morning, Linda. Yes, and I think this is a really important story, and well done to Anne for bringing something important to everybody's attention.
Very brave of her.
Very brave, but also really relevant, and I hope the listeners will continue to hear the full story during your programme. An enduring power of attorney is something that you can make while you have all your faculties, and you nominate someone to look after your financial and property and other assets and affairs after you become incapable. So,
should that be a relative or a husband or a wife or a friend? Who can that be?
Well, you choose, and what you want to choose is someone who will be, if you like, around at the time when you are maybe suffer a stroke or an illness and lose mental capacity. And generally speaking, it's a trusted member of the family, a child or a nephew or niece, but it can, of course, be a friend or a professional person who you nominate, and you have complete trust that they will look after you in your interests and will not simply use the entitlement and authority they have to benefit themselves. It's all for the benefit of the person making the enduring power of attorney.
And it can be more than one person.
And it can be more than one person, and those more than one persons can act jointly and make decisions so that you can build in some protection that person A can't act just on their own. It has to be a joint decision of person A and person B, who you nominate, you select, and you decide to make decisions on your behalf when you no longer have the mental capacity.
And it doesn't have to be the executor of your will.
It doesn't. They can be different people. They're performing different functions. A will only speaks from death, and an enduring power of attorney will apply whenever you lose mental capacity.
So the important thing is that you take it out at the right time. When is the right time?
Well, there's probably no time like if it's in your mind.
No time like the present. Yes,
if it is in your mind,
Christmas
do
thing.
it. Do
Yes.
it now while you think about it and it's in your mind. But very often, because it's a simple enough form and it's pretty inexpensive to get completed, and it's not terribly complicated, at least the enduring power of attorney form that we have in Northern Ireland, people would do this when maybe they're seeing their solicitor in connection with other business. They're in to make a will. Invariably, a solicitor will say you should make an EPA at the same time.
Well, quite often people will ask this programme about DIY wills. You see them in newsagents and online, etc. I know you're going to say take the advice of a solicitor, and you would, wouldn't you? But can you do your own enduring power of attorney?
Of course, and it's not a difficult form, and there's some really excellent guidance, in fairness to the Courts and Tribunals website, and the Department of Justice have excellent guidance on how to fill in an EPA form. And as I've said, they're not complicated, but you do have one or two little decisions to make. Is it to be joint people if you appoint more than one? Is it in relation to all of your property and affairs? And there can be an important additional comment you can make about which jurisdiction, if you're operating outside of Northern Ireland and have assets there, you can nominate which law of which jurisdiction should apply.
I think we'll be talking about that in a lot more detail after 10. But just before we finish for now, that just sits in the solicitor's office or in your safe place. Nothing happens, that enduring power of attorney, until it's registered.
Well, it is a power of attorney, so it can be used, even when you have mental capacity, if you were abroad or away and needed something signed.
But there's one more step, isn't there?
Generally speaking, you have to then register it when the person who's given the power becomes mentally incapable. And that registration is to protect the person who is mentally incapable, that somebody isn't taking advantage of them. So there's a registration process and a notification process to the members of the family of the person who has given the power of attorney.
Well, we're going to be talking a lot more about enduring powers of attorney, and we'll hear more from Anne after 10. And we'll also find out why that enduring power of attorney that she and her husband drew up and legally registered in England has no authority here in Northern Ireland. In fact, it's considered a foreign document, which is fascinating. An important story we have for you coming up after 10. We'll also be talking about wills, of course, if you have a question on that as well, because it's all sort of tied up in the one thing, isn't it? And our phone lines are open 030 30 80 55 55. You can text on 81771 or email oyb@bbc.co.uk. We hear at the moment all sorts of nightmare stories about railway journeys in England, overbooked carriages, delays, strikes, cancellations, but it's not something we often hear about here. Translink's ads for its enterprise service from Belfast to Dublin say it offers improved comfort, service and value on board our newly refurbished trains. Experience Enterprise to Dublin. Well, Hannah and her mother experienced the Enterprise to Dublin last Friday, and it's an experience they'd both like to forget.
Me and Mum, we go down once just coming up to Christmas every year. We'd had a lovely day shopping, and then coming back, it had started to rain, and we went and got our coffee, and we were down there about 6:25 or so, and we went down the terminal and got on the train, got our seat and all our shopping and all down. And we only sat down maybe about 5 minutes or so, and one of the men came down and said, could everyone in the carriage that has a red light above their seat, could you get up and all move to the back 3 carriages of the train?
And why was that?
He then explained that it was because a school or a college had been booked on to the train. So the majority of the people in our carriage all had to get up and get off. Most people all walked just on down to the carriages, but we actually got off onto the platform and headed down to the back. We could see quite clearly that the last 2 at the end were already packed, and the people were already standing, jammed in the middle of the aisles. And at this stage, the train was getting ready to leave, so we just had to get into the very back carriage. And then when we got onto the last carriage, everyone was complaining, saying that it was atrocious. And next thing, doors closed and the train starts moving, and we couldn't, we were literally just through the door. You couldn't see out a window. You weren't in the aisle. There was nothing to hold on to, and we just had our shopping around our feet, spam with hot coffees. There was a businessman to the left, and he said he'd had enough of it and opened the door into the toilet and went in there and sat for the majority of the journey. There was a lady standing beside me who was holding a baby, and she was forced to stand the whole way to Newry. And then eventually when we got to Newry, someone got up and let her have their seat. Once we got to Newry, I was able to sit on the floor. Beforehand, there was no space even to sit on the floor. It was just body to body. In the middle of the journey, there was a drunk man pushed his way up through the crowd and ended up in my face, basically. I had to turn my head to the side because he was swaying in my face with the smell of drink, holding a tin of beer.
And were there any railway employees or personnel there to see what was happening and to help anyway?
I didn't see, no. I seen one past the Newry stop. One appeared and he was walking up and down the aisle at this stage. It had cleared out a bit with the wee clicker thing in his hand counting the people. But before that, there was nobody and there was no apology or anything.
It's a long journey. How long do you think you and your mother stood for?
We were on there for exactly 2 hours. So I stood for the first hour and 40 minutes and then got sitting on the floor for the last 20 minutes.
You'd paid for your ticket. You'd got there in good time. You certainly didn't get what you thought you were paying for.
No. We booked the ticket at the start of November, a day return ticket. They always say about Enterprise, it's a relaxing journey to Dublin. It was, I am not claustrophobic at all or anything, but we couldn't even see out the windows. And Mum, she would have pains and stuff and was swaying in the journey and was as white as a ghost. Like, I myself thought at times that I was going to collapse. You were in close contact with everyone. It was so warm as well. When
you came to the end of your journey in Portadown, did you try and find someone to complain to?
Yep, so when we got off, there was no one on the platform because it was quite late at this stage. So we made our way into the station and there was a man standing at the door. I explained that we'd had an awful journey and was there anyone we could speak to in order to complain. And he handed me one of the Translink brochures and said there was a customer service number on the bottom of it to ring it.
And did you?
No, I came straight to you then.
Do you expect when you pay for a rail ticket to have a seat? Could you have reserved a seat?
I would have expected to get a seat, but I wasn't given the option of reserving a seat. It ruined the day. I've never been so glad to get off a train in my life.
Well, Hannah didn't complain officially to Translink, so on her behalf, we put our concerns to the company. And while their experience wasn't a good one, we do have some good news that's coming in the new year, down the track, so to speak. Translink told us Irish Rail passengers currently can reserve seating on the Enterprise train in all classes. However, Translink can currently only reserve seats in Enterprise Plus. But that is going to change. Translink's planning to introduce a similar reservation system to that operated by Irish Rail early next year. So that's good news. At least you will be able to, if you're on the Enterprise, reserve a seat in advance. But what about what actually happened to Hannah and her mother with the standing in the train, nothing to hold on to? Well, Translink says there are no health and safety issues with passengers standing on trains. The safety of passengers and staff is our number one priority. And the company goes on to say the train in question was a normal full Enterprise service comprising 4 Enterprise class carriages, 2 Enterprise Plus carriages and a dining car. All very well. They were standing. They weren't using any of those. And Translink says it would be happy to hear from this customer so it can follow up with the concerns raised. And of course, if you have a complaint, and I know Hannah was given the information when she got off the train, you can contact Translink through the website or on the contact centre, and our phone and operators have that number. Our phone lines are open. We're talking about enduring powers of attorney, and that always sparks a lot of questions. Brian Spears from the Law Society is with me. Just a quick question. Our bank accounts and house deeds are in joint names. We have no other partners or previous marriages. Do we need wills?
Well, I think a will would be important to clarify matters, but if you're property is in joint names, it depends on the nature of the joint ownership. There's a difference between a tenancy in common and a joint tenancy. If it is a joint tenancy, it will pass automatically to the survivor without a will, but a tenancy in common, your half, so to speak, needs to be bequeathed or will pass under the rules of intestacy. So it seems to me that it would be better for clarity and certainty to have a short will, and it's not a complicated thing to do, and if your affairs are not complicated, it at least makes sure that the destination of your assets after your death, you control, you decide, and I would suggest you make a will and don't rely simply on the operation of law.
Brian, thank you. More after 10. The rising cost of childcare?
It has gone up £4 since last year, which doesn't sound that much, but it is for a family because it pushes the annual cost up to over £8,700 a year, and that's per child.
And some parents are turning to payday loans and the legal document that has no authority here.
Immediately, our joint savings and current account would be frozen. I just couldn't believe it.
Why Anne's English enduring power of attorney didn't work in a foreign country. And And welcome back to On Your Behalf. We're talking about enduring powers of attorney. Who should have one? How does it work? What happens if you leave it too late? Why which jurisdiction you're in can play a very important role. Lots of your questions are coming in for Brian Spears, spokesman for the Law Society, who's with me here and happy to answer your questions. 30 30 80 55 55 or text 81771. Now, we began the programme by hearing from Anne, and let's hear more from her. By the way, that's not her real name. But earlier we heard how she and her husband, both born and raised in Northern Ireland, moved to England and lived and worked there for more than 30 years. And then how they moved back to Northern Ireland after they retired in 2003. Now, while working in England, they'd taken out joint powers of attorney and made out their wills, and very sensible they were. When her husband suffered a stroke and was diagnosed with dementia 6 years ago, Anne activated that power of attorney through the court in England. So the last thing she was expecting was that her bank, the Ulster Bank, would freeze the joint account, leaving her without access to their money.
I went in one day from being a woman who was confident in her financial position to somebody who suddenly thought, how am I going to cope with this? How am I going to get us out of this situation? So the chap in the bank said that I should ring the power of attorney team. And of course, in the back of my mind, I kept thinking that this would all be put right quite easily, that I would ring them and they would have this ratified through the court in Northern Ireland and I would be fine. But of course, this was not the case. The power of attorney team informed me that I could no longer have power of attorney since my husband wasn't of sound mind and could therefore not agree to it within this jurisdiction.
So all the preparation and pre-planning that you'd done, thinking you'd done the right thing, if this were happening in Bristol,
yes,
you would have been able to have acted as your husband's...
Oh, completely freely. And that power of attorney still holds within England and Wales. I was really dismayed at this and said, look, we are in the United Kingdom. But they said, well, that doesn't matter. We have our own laws here, and that will only hold good within England and Wales.
So what is available to you at this point? You have no access to your bank accounts, your joint bank accounts?
No access since September the 1st. I just feel that the message I want to get across to everybody in Northern Ireland is that even if you have a joint account, it can be closed. And nobody I've met seems to be aware of that.
So how are you managing? What are you doing?
Well, fortunately, I had a small ISA in the Ulster Bank in my own name. And on the day that I was told of this situation, I agreed to set up a sole account using that ISA. And I am now supporting both of us for our daily needs with money from that ISA.
But that can't go on forever.
No, it can't. And what I want to say to the Ulster Bank is there has got to be a fairer way of dealing with this. Joint to me means more than one person sharing. And in that case, both of those people sharing should be given proper recognition. Now, I know what they're doing. They're guarding my husband's assets. But who is guarding mine and what are my rights here? I have none. I'm a non-person. I have 42 years of salary and savings in that bank and I have no access to it.
Well, let's pause Anne's story for a moment. Brian Spears of the Law Society is answering your questions 30 30 80 55 55 and text 81771. In spite of all that forethought, in an enduring power of attorney that was drawn up in England, Anne's joint account, which includes, as she says, her money, her savings, is frozen. Whose rights are being protected and what are her rights in this situation?
Well, isn't it a balance, Linda? We did say this was an important story, and I think the listeners can see that and hear that for themselves. It's a balance between the person who is incapable, potentially vulnerable, against the rights of the other joint account holder.
It would appear to me it's completely imbalanced because it's frozen and she's got no access. It would appear the seesawed the other way completely.
Yes, and the banks will, when they are on notice that someone is no longer capable, they will freeze the account because the other capable joint account holder is able to operate it, but the person who is incapable can no longer give consent and approval for the joint operation of the account.
Even though half is hers.
Even though half is hers, it's arranged in a joint account, and the Bankers Association have this rule that when they are aware that one joint account holder is no longer capable, then they will not allow the account to be operated unless they are presented with an enduring power of attorney or some other legal document or a controllership order, in which case then the person who is the joint owner can then access and operate, but that will take time and there's some complications in doing that. So this will come as a surprise to many people, but that is the position.
Well, we'll come on to that, and you're right, it is a most unusual situation. I wonder, is it unusual? Are you in this situation as well? Because it's not just Anne's money that's been frozen. She says the few benefits that her husband is entitled to have also been locked away.
The only monetary allowance we get from the government is attendance allowance for my husband, and that is safely locked in the bank, as is his winter allowance for fuel. That's safely in the bank as well. Now, their answer to that would be that I could go to them and ask for an allowance, but I will not go cap in hand to ask for an allowance from my own money. And that's my stance.
And you might say that's understandable that she feels that way. She was told to take the matter up with the Northern Ireland Courts and Tribunal Service, which she did.
As they passed me from department to department, I got more and more dismayed and upset because the Power of Attorney Office said, we can't deal with you now. You can no longer have Power of Attorney, in which case we now pass you on to the Office of Care and Protection. And the chap there was extremely nice and said to me that my only choice now was to apply for controllership. And when I got the paperwork, that's it there, to fill in, I just couldn't believe it. The money will be under the Office of Care and Protection, and they will decide how it's split. And when I want to use any significant amount of money, I will apply to them and they will ratify that.
And there'll be a fee for doing that?
Yes.
So you have to pay to get your money?
I believe it's something like £80 a request for their admin of this.
So every time you want to access what's yours and your husband's, you have to pay?
Yes, quite correct. And as well as that, I pay a fee, for this care and protection. And then yearly, I think, from what I read on the computer, that it's about £250 yearly for them to audit my accounts.
And this for someone who'd thought and planned and made all kinds of arrangements for this possible situation. And equally, I imagine it would work the other way. If you'd taken out your power of attorney in Northern Ireland and then gone to England or Wales, you'd be in the same situation.
Well, I'm not sure. I'm not clear on that point. And I just wonder if they show any more leniency. To me, that final blow from the Care and Protection Office was utterly devastating. I would say for a week I was in a sort of shock and couldn't accept it. I couldn't accept that this was just. It may be the law, and it has been made clear to me that it is in fact the law. And I do accept that, but I don't accept that it's justice.
Well, your husband made his intentions very clear. It's not as if you didn't get round to it, or he had a stroke and it was too late for him to be able to sign it. He made his intentions quite clear legally. in one jurisdiction.
Yes. And I feel that everybody knows that that is truly done and legally done. And the paperwork can be obtained both from the solicitor in Bristol and from the Bristol court. And I felt in my mind that this was fine. It would just be then stamped or ratified by the government here. But no, it isn't the case. And these are the two issues that I want to highlight. The first one being that a joint account can and may be frozen when one partner loses their mental faculties. And secondly, that a power of attorney drawn up in England is treated here, and I quote, as a foreign document.
And isn't that the nub of it? Now, Brian Spears, spokesman for the Law Society, Anne says it was done legally, etc. All the paperwork is there. Enduring power of attorney drawn up, registered in a court in England, considered a foreign document. Is that correct?
No one listening could have anything but sympathy for Anne, who made all the necessary plans and arrangements, and she would have been right to think that she'd done everything right. And it must be distressing for her not only to cope with her husband's situation, but then to have to encounter all this, what seems like slightly over-bureaucratic lawyering.
Well, she's had no money for 3 months. You're quite right that she's coping with the stress and strain, full-time care, and now suddenly all this paperwork and all this legal jargon's been thrown at her, and she has had no access to her money.
Absolutely right. And I'm afraid the situation is, even though it is surprising, that within the United Kingdom there are three main separate jurisdictions: Scotland, England and Wales, and Northern Ireland. Now, Wales is becoming increasingly its own jurisdiction with its devolved assembly, but for the purposes of the mutual recognition of these type of documents, they are three separate jurisdictions. And under something called the Hague Convention on International Protection of Adults, made in 2000, it is possible to recognise documents made in other jurisdictions, but only Scotland within the United Kingdom has ratified that Hague Convention.
Did this come as a surprise to you, this situation?
It came as a surprise to me, but not as a surprise to the Law Society, because within the Mental Capacity Bill that was passed on the 9th of May 2016, in the run-up to that, the Law Society did make detailed submissions to the Assembly and highlighted this very issue. So it is known to, if you like, the particular specialist committee within the Law Society, but I would be very surprised that it's known generally amongst even the legal community, and certainly the implications are very widespread in that if you have assets in England and have made a power of attorney there and come here, it won't necessarily be recognised for your assets in Northern Ireland, and people really need to make a power of attorney document in the jurisdiction where they have assets.
And yet people more and more are moving around, living somewhere, working somewhere, retiring somewhere. This must be more common than maybe it was before.
Well, it's completely common. I mean, not everybody has a holiday home elsewhere, but many people do. People help their children in university in Dublin or in England, and they might assist them in buying a property rather than incur the high rental charges. And people will have assets outside Northern Ireland, and this type of situation could apply. And the lesson is, until they are mutually recognised within the United Kingdom, then you do need a power of attorney for each jurisdiction.
And of course you have to pay for that. Is there an average price for drawing up? You said it's quite reasonable when you're doing your will, but can you put a fee on that?
Well, in Northern Ireland it's probably something like £50-75 to do an enduring power of attorney. But in England it's not an enduring power of attorney anymore. It's something called a lasting power of attorney. And that can be quite good, but it's more complicated. And a lasting power of attorney can deal with property and affairs and also health and welfare decisions, because the enduring power power of attorney does not address healthcare operations, decisions made about your general welfare and health.
They both cost money, of course, and people will have to take that into consideration. But just to go back to Anne, we went to the Ulster Bank, and the bank told us the safety and security of customers using our accounts is our top priority, and issues around accessing or operating accounts can be sensitive. The Ulster Bank says we encourage customers to engage with us early about any changes in circumstances, and we'll be happy to explain any of our requirements. We maintain a careful record of customer authorisations in line with our legal requirements, including accounts with multiple users, in order to protect the finances and well-being of all our customers. That's the bank's view. What about the courts? Well, a spokesperson for the Office of Care and Protection, it's part of the court service in Northern Ireland, told us basically because there's, as you've been saying, Brian, no provision in law to recognise an enduring or lasting power of attorney made outside this jurisdiction, Northern Ireland financial institutions here are under no legal obligation to recognise them. But Brian Spears, I'm wondering, they're under no legal obligation to recognise them, but does the law actually prevent them from doing so? Did they have any way of being, as Anne said, some leniency because it was a legally drawn up document? Could they have recognised it?
Well, I think that there had been a sort of unwritten, unspoken, almost convention that people would do their best to assist. But it's very difficult for a bank, if they're technically doing something wrong and it's not lawful, then it's very difficult to stand over that. And it is a question of balance, because you are in effect taking decisions and making decisions over the assets of somebody else. And no doubt there will be people who have experienced people taking advantage of that situation and blaming a bank for putting no checks and balances into the system. In Anne's case, it appears that there's no question of that, of course, whatsoever, and she has suffered because of this overcautious but nonetheless correct approach.
Well, we put the same question to the Office of Care and Protection, and they told us, funnily enough, to seek legal advice, which is why I'm talking to you, Brian. But you mentioned the new Mental Capacity Act, Northern Ireland's 2016, is coming into operation. Is that going to change things?
Well, it will change things, and it is in operation, but it hasn't technically commenced yet. It came in on the 9th of May, and it will introduce the lasting powers of attorney that I reference, but it also, and most importantly, leaves in position this very handy, easy to operate, enduring power of attorney document.
But not yet.
But not yet.
When might it?
Well, that's not known to me, but just before I make a comment on why it hasn't yet commenced, the Mental Capacity Act also makes provision for recognising these type of documents made in other jurisdictions, including England.
Well, we've been told it might be 2 years. But the other thing is, Brian, since we started asking all these questions, and Anne has been very brave in coming forward and highlighting this for other people, Anne has now got a letter from the Office of Care and Protection. It essentially tells her that while she still can't register the enduring power of attorney here, the one she drew up in England, she can bring it to the Office of Care and Protection along with some other required documentation. It's going to cost her £75, and she'll get an official certificate that will give her access to the joint bank account. So there is a process, and if that had been clear to her at the outset, it might have saved her a lot of stress.
It would have saved a lot of stress. I would say it is still a pragmatic answer to something that gives comfort all round, that she is entitled to operate, that she needs to get access to the joint account, and I would suggest it's a more pragmatic, workable solution, which is nonetheless to be commended for that, and it will allow her to get into the joint account and use it. But technically speaking, as things stand at the moment, it is still not legally correct.
Indeed, but going to indeed at least help her situation, and I'm glad we were able to get that clarified for her. Of course, if you don't draw up an enduring power of attorney, then it gets very complicated and very expensive. I remember going out to a woman once whose husband had Parkinson's disease, and they'd meant to do it. They kept meaning to do it, and he wasn't too bad, and then suddenly he couldn't speak one day and couldn't make his intentions known. And they were having to go through a court process for every financial transaction. Tell me how controllership works.
Well, it is controllership, and of course you can only make an enduring power of attorney when you have mental capacity. So do it while you can. So far as a controllership is concerned, that is a much more complicated court application. It is governed by the type of administrative fees that Anne has referenced, and it requires a more intrusive oversight to what you do with the manner in which you expend money on behalf of somebody else. And it is back to this question of protection and balance. You are making decisions and using somebody else's funds and assets, and the court will say, well, it's right and proper that to look after the vulnerable person who's incapable, somebody needs to be looking over the shoulder of those that are taking and making those decisions.
But it's quite laboured to get each transaction and costs money each time, and
Absolutely.
then there are accounts that have to be done at the end of the year. Interesting question from a texter. Would you not be better off not having a legal power of attorney? If you've got a joint bank account, if something happened, can the bank still freeze the account?
Well, that's exactly the position. If you have a joint bank account, it's better to have an enduring power of attorney. Or you might want to organise your affairs into separate bank accounts, but that goes against the grain of many couples who, what's mine is yours and what's yours is mine, and they operate their whole lives, are intertwined. They have joint accounts. It's very, very important message to get out that while you can make an enduring power of attorney, but also make one in the jurisdiction where you have assets.
A valid one. Mary says, my children have always thought it odd. My husband and I have had separate bank accounts the last 43 years. We've been married. She says, now I can justify it legally. I've got lots of questions coming in by text and by phone for you, Brian, if we could just kind of whisk through these.
Yes.
How can an ordinary member of the public get a form for power of attorney?
Well, the answer is Law Society has them. They'll make them available, and that's where you go. Just contact the Law Society and you can get an enduring power of attorney form. They're printed forms, and they're also readily available from all solicitors' offices.
And if someone's got their facilities but you'd like to help them, say it's a mother and daughter, mother and son, and they want to help them, maybe they could get out of the house a lot. Is there something interim legally to say that I can manage my mother's bank, etc., rather than the whole power
Yes,
of
that's a
attorney
good
being
question.
registered?
Of course, you can simply appoint them with a power of attorney. The advantage of the enduring power of attorney is it lasts after the person who has given that power over to the attorney becomes incapable. But an enduring power of attorney can be used as a power of attorney, and I think that's another advantage because plenty of folk do look after an elderly relative, and this simply gives them legal status for doing that.
I think this question relates to mental capacity. Teresa says, do solicitors make a medical diagnosis when an elderly person's making their will? If they're confused or whatever, is there a legal framework solicitors have to have a medical certificate if somebody's over 80 or 90?
Well, I suppose the answer is it all depends. Solicitors are, of course, not medical and should not stray into that area, but many solicitors will want to check when they're meeting the client making a will, are they under duress from any other person, and do they have all the what might be called faculties. So very often solicitors will ask questions about their family, orientating them to what their assets are, and if there's doubt, solicitors will say that unfortunately we need to get checking up with your doctor that you have capacity.
So that happens.
And mental capacity is quite a tricky area because people can be in and out of competence, people can have lucid intervals and so on, and hopefully the mental capacity bill, which is now law, will commence, and that will help to clarify these issues of capacity.
That's interesting because I read in some of the information on the Law Society website that what happens if I want to revoke it, if I get better, so to speak, once it's enacted or once it's registered, is that it?
Well, a will can be revoked at any time, but you need to be competent to make a will and you need to be competent to revoke a will. There is something called a statutory will that can be made for people who are no longer competent, and this is something that attorneys can make in conjunction with the court. And that's quite interesting that, if you like, a will can be made for you, even if you no longer have mental capacity. But you can imagine that there would be all sorts of checks and balances required for that process as well.
And with revoking or changing your mind with an enduring power of attorney, can you deregister or change your mind in that too?
You can. You would have to do that quite officially and have a record that you no longer wish to continue with the power of attorney or the people that you have nominated, and that would require you to make a new enduring power of attorney through a solicitor who will destroy and certainly mark the original one as having been revoked.
What's the average cost of making a will, the solicitor Joanne says, and is a do-it-yourself will legal?
A do-it-yourself will is legal, but there are a lot of formalities around a will, and of course if you are wanting to make sure your assets end up going to the people that you want them to go to, it is prudent in the long run. Spend a little bit of money to get it right is good advice. The average cost, they can range from a very simple will, it might be £100 or even less, but of course with complicated wills, multiple assets, numerous beneficiaries and assets out of the jurisdiction, and possibly wills for inheritance tax planning, then I think more time will be required in the drafting and preparation and understanding, and the cost will rise according to the time and complexity.
Bigger bills, and one texter says people should be made aware of costs. Completing an enduring power of attorney, to say it's relatively inexpensive can still mean a lot of money to a lot of people. This one's interesting. My wife's in the hospital. She has money in an account. I have power of attorney. The house is in both our names. If I sold the house, could the government claim any of the money? Are we mixing our metaphors there between power of attorney and...
I think there's quite a lot going on there with the cost of residential or care mixed in with can that be the asset, the value of it be used to pay for that care. I think you would have to be extremely cautious in selling an asset if you live in it, but if it's your house and you live in it, even if it's joint, you need another house to live in, then you would be entitled to use the sale proceeds of a jointly owned property to buy another property, and I suspect that will not be recoverable by and to be used for the cost of that health care in that situation.
And just final question, I think this is a texture we maybe had before. Could you say, can the bank still freeze an account if there's no power of attorney, if they consider one of the people in the joint account to not be able to manage?
Well, that's it, because if the bank is on notice that somebody is incapable, then they have to act in the way that we've described. And the question arises if the bank are never told. But that will depend on the individual facts at the time. But if the bank don't know, then they aren't on inquiry or put on inquiry. But if they suspect that something has gone wrong, and in particular they have to act to protect the assets of the vulnerable and incapable person. And it's that balance that we've mentioned throughout this programme.
Balance. Brian, thank you for answering so many questions. I apologise we don't have time to bring you the information about the childcare cost survey this week and how much it's costing parents in childcare. We'll bring it to you next week. That is it this week. There's lots of information on our website and links to the Law Society, but for now, Brian Spears for the Law Society, and for me, Linda McCauley, and On Your Behalf team, thanks for being with me this morning. Goodbye. You've been listening to the On Your Behalf podcast from the BBC. For our terms and conditions of use, please go to bbc.co.uk/podcasts. See you next week.